Chairman, let me, colleagues, friends, I'm very honored to be here today, and I would like to thank the Dubai Judicial Institute for this invitation. It's not easy to speak after so many distinguished and outstanding speakers, especially while I will address an issue which has been already partially covered by other speakers. So my subject will be the ethical chart on the use of artificial intelligence in the judicial system. So I will have to speak on how artificial intelligence will be used in the judicial sector. And why this subject is so up to date. So the many questions you have made to the previous speakers certify that this is a very debated topic. And I would like to go back 1922. Max Weber was a famous economist and lawyer as well in Germany. He wrote a treaty, Wirtschaft und Gesellschaft, society and economy, and he explained why legal certainty is a precondition for the well-functioning of the market. Trade requires a clear and stable regulation. And in the view of Max Weber, the judiciary must offer quick and predictable answers to any economic operator and must guarantee a uniform application of the law. So the idea that the judiciary has to decide in a swift and predictable manner may help to understand why the discussion on artificial intelligence is so important nowadays, especially in systems. I'm speaking for the system of the country I live in, Italy, very often gives a slow answer to demand of justice from citizens and corporations, and sometimes it's not so predictable. If you go to a lawyer and ask how many chances will I have to win my case, the lawyer, in most cases, will say, you have, quite a fair chance to win the case, but I cannot tell you for sure how the result will be. So there's a widespread idea that artificial intelligence may help to overcome the shortcomings of the judiciary nowadays and help to give more immediate, predictable, and objective answers by solving disputes. So, and the interest of artificial intelligence is even higher in countries where any decision bind the other judges, where the principle of stare decisis applies. So in that case, having a system which might detect how a previous case has been decided by other courts could be very helpful. So I will address my presentation. I will start by giving some remarks on how artificial intelligence might be used in the judiciary, but I will be very quick because other speaker, Mr. Mutawi and Mr. Turner as well, has covered this issue. I will provide the case of Italy. Why Italy? Because Italy is a case where there's a lack of use of artificial intelligence and technology in the judicial sector, but at the same time, there is acknowledgement of the need to have a wider use of technology and artificial intelligence to fix the many problems that the judiciary now is facing. And, but if we arrive to the conclusion, as the speakers, the previous speakers underlined, that there is space for use of artificial intelligence by the judiciary, then we have to decide if it's possible and how is it possible to fix the problems that artificial intelligence poses. And first of all, the problem of algorithmic discrimination, so the errors, the biases which might be inherent in the use of artificial intelligence. And from this point of view, as Mr. Turner told us very convincingly before, the setting of ethical principles, which will be, a first phase in order to have a proper regulation in place, will be very important. So I will look at the ethical charter on the judicial use of artificial intelligence. So it's not necessary now to describe what artificial intelligence is and what is a legal definition. Mr. Mutawi yesterday explained to us very clearly what artificial intelligence is, which are its potentialities. And Mr. Turner also have provided with a legal definition of artificial intelligence. And we learned, and we are all convinced, that the key feature of artificial intelligence is the autonomy of decision. It's a machine or algorithm capable of learning from the environment and taking decision independently. So it makes decision independently, makes artificial intelligence make its own decision. That's why it's so different from software used until today. And we also learned that there's a difference between machine learning and deep learning, which will enhance the potentialities of artificial intelligence. So we also learned that artificial intelligence has today a common use. I want to make you an example. 2013, the New York Times published an article on Angelina Jolie. Angelina Jolie is a famous actress, and she decided she was completely healthy, beautiful, and she decided to undergo a double mastectomy. Why? She went to a doctor, she had a blood analysis, and the doctor said that through a machine, and which was based on, some sort of technology, I don't know if it was proper AI or some sort of software, they told her, on the basis of other cases, we can tell you that you have a high probability to develop breast cancer in the near future. So she decided on that assumption, on that prediction, to have a double mastectomy. So this is an example of how predictive tools, artificial intelligence, can influence our everyday life. And so, in addition to all other uses that we know on our daily life. So, if artificial intelligence is so much used from facial recognition, we had many examples. It's useless now to go back and explain again what we learned today. So why not using artificial intelligence in the legal sector? And I would say that artificial intelligence may be relevant for the judiciary under two different aspects. The first one is the issue of liability. So who would be responsible for the use of artificial intelligence systems? We have covered this topic, and we have learned that this is an open issue. The other point, and on which my presentation will focus, is the use of artificial intelligence by the judiciary. Why I will focus on this topic? Because I am a member of the Italian Council for the Judiciary, and this is a highly debated topic within our judiciary, but I would also add that it is highly debated also at international level. For instance, I'm member of the board of the European Network of Councils for the Judiciary, and we are focusing on how to use technology and artificial intelligence to help any national judicial system to offer a better service to citizens. And the example of Italy. Italy is an example where really we have we don't use artificial intelligence, but we are convinced that artificial intelligence will in the near future be used by courts and tribunals to render a better service to citizens. Please consider that in Italy, but as in many other countries, we have problems for the duration of cases. If you have a litigation could end after many years. It's a completely different scenario, for instance, than the UK, where courts decide quite quickly. And we also have problems with legal certainty because courts may decide similar cases in different ways. We have many examples of courts having conflicting interpretation of the applicable law. So we had some, I would say, primitive examples of, try to introduce solutions to give some guidance to the citizens and to the courts in order to have an idea on the duration of cases and on the outcome of cases. And this was an example. It was very, let's say, I will say it was a software which was developed by the Florence University, which was developed in order to calculate scales in family cases, so the amount of child support in cases of separation, divorce, of rupture of a de facto union, and so on. And the software was directed to citizens and to judges as well. So the idea was that the citizens would be able, just using this software, to understand the amount he would be entitled in case of separation, and also to give a guidance to judges. And this is the website page. It's in Italian. I will skip it immediately. And there was a portal, and the system required the user to register on the portal, to pay a fee, and to provide a set of data, which was a duration of the marriage, how many kids, which are the assets, the income of both parties, and so on. And the algorithm gave a response, for instance, on the amount that most likely a tribunal would have granted in case of separation to a spouse. What was the problem? It was a traditional software which was not able to understand the peculiarity of each case. For instance, the system considered how much time each parent spent with the children, but did not take into consideration the quality of time that each parent gave to the children. So it was not able to give, let's say, tailored responses to the questions posed by the users. And in addition, since it was not self-learning, it had to be constantly updated by the programmer. And by the way, it was used in certain cases by the lower courts, but the higher court finally decided that in determining the amount of allowances due in case of separation of divorce, it's not possible to rely merely on mathematical calculation. It's something which is up to the judge to decide by weighting up the circumstances of the case, and so it needs a judge. It cannot be replaced by a machine. This kind of assessing of scales. So, nevertheless, other courts tried to give guidance to citizens. We have many appeal courts that publish on their website let's say, reports on the established case law on certain given matters. So the idea is, by accessing the website of a court, a citizen might have guidance on the duration of a possible case and on the possible outcome of that case. This is an example of the web page. But again, this is a system that cannot work. Why? Because how can those are reports prepared by trainees under the supervision of a judge, giving the results of the well-established case law on a given matter. But in order for a person to understand whether that established case law is applicable to its case, it's not so easy, and therefore it might also be misleading. So again, we are all convinced that these examples are not working, but at the same time, those examples certify that there's a need of giving some sort of tools to citizens and to judges to make the judicial process quicker and more predictable. So in order for a AI system to work, it's necessary to have data. And we have, in the Italian experience, we have data. Why? Because we have completed a reform which has introduced a digitalized process. So as you mentioned, as Mr. Turner mentioned to us with respect to the UK experience, in Italy, nowadays it's not possible anymore, if you have a civil case, to lodge paper or hard work. You have to do everything through the internet. And so the judges will receive all the submissions, all the documents through the web. And this facilitates very much the work of the courts and allow the court to have a database of all decisions, because the database is a precondition to make artificial intelligence work properly. Only if you have a complete and reliable database, it is possible to have, a AI give reliable results. Of course, it is not sufficient to provide the provider of AI with a complete database. We will have a lot of issues to be solved. Think about IP issues and privacy issues. This is a subject which has been highly debated in France. So in France, where there's a project to have a complete database of court decisions, there's a discussion whether to erase from those databases the name of the parties, because otherwise anybody could be able to have personal information about a single person. Think about the decision of the case. So in any decision, we publish the name of the judge who took that decision. And with AI devices we have nowadays, it would be possible to profile a single judge and to say, okay, that judge is, in favor, as some sort of inclined to take some kind of decision, and let's avoid that judge. And this might lead parties to use a sort of judge shopping. So let's keep the judge which, is not so favorable to a corporation in given cases, and let's try to seek another court where we can file our complaints. So in order to avoid that, in France, it's highly discussed how to erase from all the documents which will be stored in the databases the name of the parties and the name of the judges, which is not easy, because name of parties and name of judges and name also of technical experts will be impressed not only in the final decision but in all other documents which will be stored in the database. So once we say, okay, let's imagine that now we have data. Now we have found a solution to avoid, problems of privacy or IP. We have to find a way to make AI reliable. And so this is something we have topic has been addressed a few moments ago, and I really appreciated the presentation of Mr. Turner and the solutions, also practical solution he gave us, how to make artificial intelligence reliable. And because the idea, the old idea that artificial intelligence, that the algorithm could help to avoid errors and biases which usually affect the human decision making, is fake. Because it's certain that errors and biases could be even increased by use of artificial intelligence. And we have listened to what happened in the Loomis case. The Loomis case was a clear example. There was a huge debate in the US about this case, and where a person, Mr. Loomis, was sentenced to 6 years jail based on the outcome of an algorithm which indicated to the judge that he was a danger, so he could commit crime again. The reasons, the defendant made the argument that how can I be sentenced to jail on the basis of the results of an algorithm? And this algorithm is, by the way, proprietary, so which means it's not open. And the court told him, you may make a contrafactual proof, so you know which are the information used, you know what is the output, and you could challenge the reliability of the algorithm. But the main argument was that in that case, the risk assessment depended partially on the compass, but it was the result of the compass was one of the elements taken into consideration by the judge to establish its own conclusion. And by the way, we found out there was an association which found out, proved, gave evidence that that compass system was biased. Which are the possible causes of biases in AI? The first one might be a non-correct training of the algorithm. So if you train the algorithm, you remember Mr. Turner explained to us very well that in machine learning, an algorithm has to be trained on a given set of data. If those data are partial or are biased, then the result of the algorithm will be necessarily biased as well. And for instance, if I concentrate the data on a certain type of consumer in order to assess the, if we can get, if a bank can grant a mortgage to that given and verify that there's, for instance, cases of non-payment among people living in a certain area, having a certain income and so on, then it could give a non-correct answer. And then there's a statistical discrimination. For instance, if an insurance company finds out that men like to drive more quickly and have more accidents, they probably would tend to charge for insurance policies men more than women. And someone could say, yes, I'm a man, but I drive very carefully. Why should I pay a higher insurance policy? So it's a matter of fact that despite all, the shortcomings, AI is used more and more and will use even more in the future. And so there are many issues in the use of artificial intelligence. I would like to give you an example. So artificial intelligence is used in Italy by the public administration for many purposes, including recruitment process. And there was a case where a recruitment process was controlled, decided by an AI device, and the applicants, many applicants, claimed that the device made a wrong decision. So, and this was a quite important case because, first of all, the judge had to decide, is it possible to use an AI system in a decision taken by a public administration which will affect the life of people? So, moving one person from one office to another, to a city or another. And the Court of First Instance, the Administrative Tribunal of Lazio, said, okay, it is not possible to use AI by the public administration because the administration requires a decision taken by a human, weighing up all the interest involved in the decision. The Council of State, so the appellate court, disagreed with that approach and said that, in general, use of artificial intelligence by administration is very useful because can increase the efficiency, the cost effectiveness of decisions. However, the Council of State said the principle of Italian law on administrative procedure, which are set forth by a law on 1990, should be applicable also to algorithmic decisions, which means that any interested person should be in a position to have access to have information on the logic used by the system and must have the possibility to challenge the decision before a court. So the Council of States said, okay, in administration, we have a set of legislation. You should simply apply that set of legislation to the algorithmic decision. And the argument must be transparent, the decision must be reasonable, and so on. There has been a general discussion on whether those principles, transparency, judicial protection, would be applicable also outside the administrative action. For instance, if I go to a bank and ask for a mortgage, nowadays the decision will be taken by an AI device, which will analyze whether I'm a reliable person or not, based on a set of data which probably I don't even know. Where I live, my income, if in my family someone has not paid his debt, and so on. So how could a person be entitled to access and to have information on the system which is used to take decisions which affect his or her interest. And the answer is the General Data Protection Regulation. This is a regulation of the European Union, which has entered in force in 2018, which sets forth principles on the use of personal data, and this provision contains a set of principles that could be used also for artificial intelligence, because artificial intelligence requires processing of personal data. And since there is a processing of personal data, then the interested party may claim a right to access the data and to have information. According to Article 15 of the GDPR, any interested party has the right to obtain from the controller, so who is a person who processes personal data, information on the existing of automatic decision making, and in that case, also information on the logic involved. And Article 22 of the GDPR grants any person the right not to be subject to a decision based solely on automatic processing, as a general principle, which may have a number of exceptions, for instance, when the interested party gave its consent to the use of its data for an automatic processing. So, having said that, at the end of the day, artificial intelligence can be defined as a black box. So, how can GDPR be used? How can we obtain transparency when we don't know which is the algorithm that time by time is produced by the device, the machine learning device, according to the experience gained? So probably this is a question, and we have already discussed this question. But you know, sometimes also human decisions can be seen as black box. Sometimes you wonder why this man took this decision. And very often also judges take decision on the basis of arguments which are not fully explainable. We heard before the case of a homeless stealing something. And we said, okay, there must be some sympathy in favor of that person. And might be the decision for a homeless stealing something in order to survive could be different from a rich man stealing something just, you know, for joke. But what is the rationale behind that? What is the empathy? How can I explain the empathy, the sympathy, which drives me, judge, to take a decision in a case different from another case? So sometimes, you know, we must not exaggerate. Black box is a problem sometimes also in human decision making. So, but let's leave this problem. But if we find out that AI, at the end of the day, provides reliable answers, I might be tempted to say, who cares if I don't understand how AI came to that decision? The decision was right. And in order to give you an example, there was a predictive software developed by the University College of London, which proved to be able to predict with 80% accuracy the outcome of a case before the European Court of Human Rights. You might say, yes, there's a 20% percentage of mistake. But 20% percentage of mistake, yes, it's, I would say, I don't want to say common, but it's possible also in cases which are decided by courts. How many decisions are reversed by appeal courts? In Italy, probably the percentage is higher than 20%. If you go to a lawyer and you ask me, tell me which is the percentage that I might win the case, I believe it would be very difficult, if not impossible, to find a single lawyer tell you you have more than 80% chances to win the case. So it's a high level of accuracy which has been proved can be reached by an AI device in predicting the outcome of disputes between the European Court of Human Rights. Anyway, is it possible? We had a question, has been posed many times. Can we have the word, I like the word very much, judge boats? Can we replace judges with robots? My answer will be no. Why? Because we have constitutional constraints. The Italian Constitution would prevent to replace a judge with a robot, but the Article 6 of the European Convention of Human Rights, any person has a right to a fair and public hearing within reasonable time by an independent and impartial tribunal established by law. And the same, the GDPR. The GDPR would prevent any public authority from imposing a decision based on automatic processing of personal data if that person is not accepting that. So I would say that a robot cannot replace a judge, even partially. So even that's a good example from the Italian Constitutional Court. Italy passed a legislation in order to facilitate the dismissal of workers and avoid disputes about the amount of compensation due to workers, and the legislator established by law the amount due to the worker in case of dismissal. And the Constitutional Court said this is unconstitutional because the amount of damages due to the worker in case of unlawful dismissal must be determined by a judge, taking into consideration many criteria, the dimension of the corporation, the number of employees, the size of business, and so on. So the principle of judges' self-determination. So the Italian Constitutional Court said it very clearly, we can not have automatic determination in matters like this made by the legislator, imagine if made by a machine. So having said that, is there space to use artificial intelligence by the judiciary? So someone many scholars, not only in Italy, they doubt it. Why? They say, okay, What if a predictive device would be developed and put at disposal of judges and of private parties? So the idea is that the algorithm may condition the judge's decision. So if I have an algorithm telling me that the outcome of this decision would be X, if I want to decide Z, I should give a sufficient motivation for that. And therefore, some scholars says we don't want even that the judge be conditioned by an AI device. So let's go back to the case of Angelina Jolie. She was healthy. She made a decision because an algorithm told her that most probably she would have developed cancer. But, we have no certainty that she would have effectively developed cancer in that case. Having said that, I believe that there is a huge space for use of artificial intelligence in the justice. Calculation of scales. We already gave an example. In that case, the judge could use the results of the algorithm as an element to be taken into consideration for his final decision. Court management. There are many, many courts that are, let's say, overwhelmed by cases. This happened, for instance, to the European Court of Human Rights. And European Court of Human Rights has had an incredible success because each single person could file a complaint before with the European Court of Human Rights. And the response given by the court in many, many cases has proven so successful that there is an increasing number of persons seeking protection with that court. So if you want nowadays to lodge a complaint with the European Court of Human Rights, you have to do it through a web page, which there's a template where you have to clearly indicate which are the provisions of the Convention of Human Rights which you deem be violated, which are the parties. If you have exhausted the legal remedies in your countries, because in the convention there's a principle that you are allowed to access the protection given by the European Court of Human Rights if there are no remedies available in your countries, and you have to give a very short and detailed summary of your case. So this template gave the possibility to the Court of Human Rights to put together all the cases having, similarities and to manage them more efficiently and in a better way. And for instance, AI, if applied to a solution like this, may work out very useful, to increase the efficiency of courts. And another tool is the research of precedent. Okay. Precedent is very important, not only in common law, but also in civil law. You know that common law countries are based on the principles that any decision binds the other judges. So in order to deviate from a previous decision, the judge should make a distinguishing, so should prove that the case is different from the other, or he should adopt a overruling decision, which means that they must give reasons why it changed the interpretation of a given piece of legislation. In civil law countries, there's a principle of freedom of a judge. Any judge is free to interpret the law as he deems opportune. But this principle of freedom of judge to interpret and apply the law must be weighted up with another principle, which is the principle of equality, non-discrimination. So it is true that the judge is free to apply the law, but it's also true that why you treat me differently than my colleague which had a different decision on the same case. So also in civil law countries, the precedent is very important. And having a system that can help to retrieve the precedent might be really helpful, really useful. So we said, okay, it is possible, I come to the conclusion of my presentation. So it's possible, there's room, and there will be always more room for the use of AI in the judicial sector. But this use must be compliant with the fundamental rights. And in order to accomplish this need, and considering the increasing importance of AI in a modern society and for the judiciary, the European Commission for the Efficiency of Justice, which was established by the Council of Europe, has adopted on December 3rd, 2018, the European Charter on the Use of Artificial Intelligence in Judicial Legal Systems and Their Environments. And this is a very important move because many times has been underlined by the previous speakers the importance of having ethical principle guiding the use of artificial intelligence. And in short, the European Charter set forth 4 fundamental principles which has to be complied when using artificial intelligence by the judiciary. So, first of all, principle of respect of fundamental rights. Second, non-discrimination. Third, equality and security. So, use of certified sources, not biased data, and use in a secure technological environment. Third principle, fourth, transparency and impartiality. And lastly, the principle of under-use control. So any user must be an informed actor in control of the actions made by the system when taking decisions that might affect him or her. And you might say those are very broad principles. But, you know, the ethical charter says something more. Not only those principles should be used when applying, when using artificial intelligence devices. The Charter says also that AI systems must be designed in order to meet the ethical requirements set forth by the Charter. What means that? This means that it is an obligation for every developer, for every licensor, to be sure that the system design is compliant with the ethical charter. And from this point of view, I believe that the suggestions made by Mr. Turner on certification of artificial intelligence systems, on licenses for users of artificial intelligence devices is really important and goes in the direction set forth by the charter. Because if you secure in advance that a artificial intelligence system meets the requirement of the charter, is compliant with fundamental rights, then you might have a trustworthy artificial intelligence system. You might reduce or avoid, if possible, the problems that might arise out from the use of artificial intelligence. And this charter is really important because, of course, you might say it simply set forth general principles. And being it an ethical charter, it makes suggestions. It's not binding. Yes, it's true. But an ethical charter could be also seen as a first move for a process which at the end will see the intervention of the regulator. Those general principles could one day become binding rules, and could become binding rules obliging all developers of AI system to construe their systems in a, let's say, human rights friendly fashion. And this would enhance the use of artificial intelligence and the trust of citizens. And so I may conclude that this workshop, I would say, not my presentation, but especially the previous ones, at least convinced me that AI may play a key role for the future of our society in many, many sectors, including justice. AI, if properly used, if used in a way compliant with the general principles set forth by the Charter, might help to increase the efficiency and quality of justice. Of course, there are many, many technical and legal issues to be addressed, but I'm sure that this workshop gave us some indication on how those issues might be, I don't want to say fixed, but at least addressed. Thank you. If you have any question, I would be happy to answer. No.
أولاً شكري الجزيل لعرضكم القيم.
One second. Let me. Okay.
سؤالي بصفتي قاضية من الجزائر، أغتنم دائماً هذا اللقاء القيم الكبير من أجل طرح انشغالاتي المرتبطة بوظيفتي. سؤالي: شاهدنا جميعاً الإنسانة صوفيا روبو التي تتحدث كالبشر، تبتسم كالبشر، تتفاعل مع غيرها كالبشر، قد تكون محل مساءلة. لدينا قضية السيارة الذاتية الآلية التي قتلت شخصاً في أريزونا الأمريكية. لازلت أطرح هذا السؤال المتعلق بمعضلة أو مشكلة المساءلة. هل هناك دول توصلت إلى وضع مبادئ أو معايير يمكن أن يستعين بها يعتمد عليها القضاء في تحديد المسؤولية؟ سؤالي الثاني: هل تتصورون سيدي المحاضر أنه أمام هذا التطور السريع أن نصل يوماً إلى القاضي الآلي روبو يحل محل القاضي الإنسان البشر. وهل ترون في ذلك نقمة أم أحسن حدث في تاريخ البشرية أم أسوأ حدث في تاريخ الحضارات؟ وشكرا لكم.
Okay, first question, liability in case of use of AI. I believe that this issue has been addressed. We have seen the Uber car hitting a man example has been discussed already, and as far as I know, there's no legislation setting forth criteria to solve this issue. And as always happens, it will be up to the judges to furnish general principles, which most probably will be then taken into consideration by the legislator. So this is why it is so wise, the practical indication that have been furnished to us by Mr. Tanner and Mr. Turner on, a compulsory insurance policy for the use of AI. The second issue is, would be advisable, so let's make an assumption. So we have reliable predictive AI devices. Would be good for our society to have judges replaced by AI. And I'm speaking independently from legal provision. As I told you, Article 6 of the Convention of Human Rights prohibits this kind of replacement of judges with robots. But let's assume that we have no legal constraint, and would it be advisable to have in the future a court where judges are replaced by robots? I would make some examples. Would you ever allow a robot to decide a family case? Would you ever allow a robot to decide who will have to take care of the children in a case of divorce? I believe that is something that is really, in my opinion, that requires a human being, because it requires that empathy, that sympathy that Mr. Tanner explained to us has to be necessary in given cases. But if I have a claim, there was an example which I found very interesting. So, fine for not paying park tickets. So probably we wouldn't care if this kind of disputes would be solved by an automatic AI device. And by the way, nowadays we have many small claims which are already settled by, I don't know if they are AI device, I'm not an engineer, but by automatically. I give you an example. It was 2 weeks ago, I was on a train and my train was very late, and I received a message, and the message told me, your train is late, you're entitled to a compensation. If you agree and if you want, you can go and push this button, and it will calculate the compensation you are entitled to. I made it. He provided me a compensation, 30 euros or something like that, and I accepted. I would have never gone to a lawyer to ask for a compensation because my train arrived late. And this was something which has been done effectively in a quick way by a algorithm. And I do not care if I was entitled to 30 or to 40 euros, because I know exactly that without that algorithm, my right would never have been enforced. So we will have to distinguish, as usual, between claims and cases which will be suitable to be decided automatically, and claims, and which, in my opinion, will remain the majority, that require a human judge. And this is a good news also for the lawyers, because which means that the legal profession will remain necessary even in the future.
شكرا على المداخلة. سيدة مخلوفي سلوى، قاضية بالمحكمة الاستئنافية بالعاصمة وأستاذة بالمعهد الوطني للقضاء. أشكركم على المداخلة. فعلا إن استخدام الذكاء الإلكتروني يساعد على الربح، الوقت، توفير الجهد والعناء، ولكن نحن نعلم أن المبدأ الأساسي للقضاء هو تحقيق العدالة ليس إلا. السؤال المطروح: من سيكون مسؤولا على أخطاء قد تنجم مثلا على فيروس قد يعطل أو يتلف منظومة معينة تم الاعتماد عليها أثناء التحقيق القضائي أو النظر في ذلك، وكيف يتصرف في مثل هذه الحالة؟ السؤال الثاني: ألا تظنون أن الاعتماد على استخدام الذكاء الإلكتروني قد يؤدي بمعظم الأنظمة القضائية على مراجعة أغلب القوانين الخاصة بالأدلة، إن لم نقل كلها؟ وكملاحظة، في الجزائر هناك تطبيق يمكن من خلالها للمحامين المتقاضين والقضاة توفر لهم عناء الانتقال إلى المحاكم، وذلك بمنحهم رقم سري يمكن من خلاله معرفة مآل القضية. شكرا.
Yes, again, it's really the question. So I believe after having heard all the presentation, we cannot say that, at least I'm speaking for myself, that we speaker could, give you final responses on issues which are not only issues concerning application of law, but are also ethical and philosophical issues. So the place that in the future AI and artificial intelligence should have and will have is, something that should be addressed at different levels, political, philosophical, and legal as well. And I share your fears. You say, what happens if there is a problem to the system, to the technical system? And, all the files are becomes not usable because of the virus. Yes, this is a problem. But what happens if, let's say, in a traditional tribunal, there's a fire? and all, paper files get destroyed. The same issue. Of course, you might say it's easier that a virus could attack a system than a fire could destroy a court. That's it. But, we have to find solutions. And there are technical solutions. For instance, if you, again, I really don't want to say silly and stupid things, because I'm not a technical person, but, but I know that nowadays you have systems you can duplicate, the storage of any document. The cloud offers the possibility to have redundancy and to increase the security of systems. We will always have problems, because I don't believe that in the history of humanity there was a solution without problems, but probably if we address those problems in a proper way, I believe we could find at least reasonable solutions.
شكرا لكم. يونس الزهري، قاضي مدير تكوين القضاة من المغرب. شكرا لكم سيدي على مداخلتكم القيمة. بطبيعة الحال في هذه الورشة أقاسم زملائي القضاة نفس الانشغالات والهموم لنجيب عن سؤال مركزي ومحوري، وهو: هل يمكن أن يحل الذكاء الاصطناعي محل القاضي الإنسان بكل الضوابط المحددة لهذا القاضي؟ تحدثتم سيدي المحاضر عن الضوابط الأخلاقية في استخدام الذكاء الاصطناعي، وبطبيعة الحال حينما نتحدث عن مركز الأخلاق أو الديونتولوجي في عمل القاضي، لدينا مرجعيات دولية، لدينا قواعد بنغالور، ولدينا قواعد موضوعة على المستوى المحلي وعلى مستوى كل دولة. الإخلال بهذه القواعد الأخلاقية يفتح باب المساءلة التأديبية للقضاة، أي أنه توجد مؤسسات في كل دولة تتولى تأديب القضاة الذين خرجوا على هذه الضوابط الأخلاقية. اليوم ونحن نتحدث عن الذكاء الاصطناعي، كيف لنا أن نسائل المسؤول عن الإخلال بهذه الضوابط الأخلاقية؟ هل نسائل المستخدم؟ هل نسائل المطور؟ وما هي الجهات التي ستتكفل، علما أن هؤلاء ليسوا بقضاة؟ كيف لنا أن نحاسبهم، والحال أن محاسبتهم هي جزء من الثقة المشروعة التي يجب أن نبثها في منظومة العدالة؟ وشكرا لكم.
Yes, thank you for your very interesting question. Which are the legal instruments we can rely on in case of issues arising out from errors or biases or mistakes made by an algorithm? And again, this is a crucial issue, and this is why the previous speakers asked for, they said that it will be necessary an intervention by the legislator. As of today, we can only rely, I would say, in Europe, on the GDPR, on the General Data Protection Regulation, which sets forth a set of principles in the processing of data. And among those principles, not only the principle of transparency, accessibility, the obligation to inform any user of the logic involved in any automatic decision process. We have also other principles that are very important and might turn out to be useful to address the issues you highlighted. For instance, the principle that processing of data must be made in a fair, transparent, and human rights compliant fashion. The powers that the GDPR confers on the data controller, national data controller, to impose sanctions which could be very heavy in case of violation of the principles concerning the treatment of data. But again, this is a legislation which has not been thought for artificial intelligence. It was conceived many years ago for something very different. The idea, it was the personal data, the database, which when I go into a shop and pay with my credit card, all my data will be collected and my data will be used probably for commercial purposes, but they might be used also for other purposes. We have huge problems nowadays with processing of personal data. Think about profiling people. Profiling people could be very dangerous because not only for political purposes, but also it might give rise to discrimination in employment and in other kind of. So it's important if my data are not treated correctly. We have a certain set of rules which protect us with respect to treatment of personal data. We don't have yet rules conceived for AI because it's something new, and probably the case law the main task of our judges will be to adapt those rules to the new challenges of artificial intelligence up to a date when we will find a legislator which will give an example and set out a regulation for this kind of issues, but with a warning. So technology nowadays is moving at a pace which was not even foreseeable some years ago. And we are now discussing of AI, which is something that 10 years ago we could read on the books of Asimov. And the big problem we have is that the legislator cannot keep the pace of the progress of technology. This is why the role of judges, the role of legal professionals will be always fundamental because it's probably really difficult to believe that in the near future we will have a set of rules which will fit on the cases that will arise out from the use of artificial intelligence. So the role of judges will be fundamental, the role of lawyers, the role of scholars as well. Okay, thank you very much for your attention, and feel free, I will be here if you want to raise any further question. I will be happy to discuss further.